OAS is supposed to be the forum for the debates, the political and economic debates, but basically the political debates of the state members, which are all the countries of the Americas, which is North America, South America, Central America, and the Caribbean. Canada has been always very active within OAS and with it and with its relationship to Latin America. Our institution, CEJA, has historically had Canadian funds to work on the projects, multi-year funds to work and develop our projects. Currently, we're carrying a 6-year to 7-year project with Global Affairs Canada funding, which is called Improving Access to Justice, Civil Justice in Latin America. So we've been working with Canada for many years, and before that, when we met Pierre Gilles, Canada was also involved in the criminal justice reform. I would say Canada has this special situation in which you mostly have a common law system, but you have the special and particular situation of the Quebec province, and for that, the influence of a codified criminal and civil system. So there's a very interesting mingle there of common law and civil law in Canada. I would say Canadians, the Canadian system, and institutions as the Justice Department and NJI, the National Judicial Institute, have always had eyes and ears for what's happening in Latin America. You Canadians have, I would say, a very special interest in what happens in Latin America. And as an immigrant country, you had a wave of Latin Americans immigrating in Canada during the late 1970s, during the military dictatorships, where many people actually flew to Canada to live. So I will say that, and Canada has been very active in the OAS, trying to be part of this region, realizing that you have a different, more Anglo oriented culture, and then French culture strongly, and then all the beautiful immigration of Armenians and others that have populated the west of Canada. So you are a very interesting community, mixed community, that I would say is very, very receptive to also what we have in Latin America, because Latin America is usually believed to be, as let's say, Hispanic, which is correct. But I have native blood. I'm Mapuche in part, and I have the Spanish, of course, influence, and I have French influence as well. And Latin America has probably the largest communities of Palestinians and Lebanese in many countries. Chile has the largest Palestinian community outside of Palestine, for instance, and a very large Jewish community in Argentina and in Chile as well, but especially in Argentina. You have a large Japanese community in Brazil, for instance, probably the largest, I understand, in the world outside of Japan. You can continue. I mean, there is also a lot of immigration. We are countries that were made of different waves of immigration. So Canada understands that. Now, am I critic of Canada and the U.S. not being part of the human rights inter-American system? Yes, I am critic. Because it's hard to, on the one side, sort of judge human rights in other countries, but on the other side, not submitting yourself, your authorities, your officers, your public officers, to the control of a court which is headquartered in San Jose, Costa Rica, that usually what does is to actually know cases against the state members in case of human rights violations, and human rights violations that are depicted in the chart of human rights of the Inter-American Chart of Human Rights, right? That we abide to. And this is interesting because the court has been working on ways to fulfill the responsibilities of the state members which is not only being submitted to the court, but actually having the justice system, the domestic justice system, uphold the chart. And this is in two ways. One, that what we call the human rights block, that should enter into our constitutions at the highest level, hopefully at the principles level. So it would eliminate the way you interpret all your constitution and therefore all your legislation from the perspective of human rights and what is considered in the Inter-American Chart. And usually what you would expect is also that at least the Supreme Court of every country would uphold the chart as part of a even supra-legal and at least constitutional level normative. Now, depending on if you have a scattered constitutional control or you have a concentrated constitutional control, that is the way that the Inter-American Human Rights Chart will be controlled at the same time by the justice system. So, if in a country only the Supreme Court is the one in charge of controlling the constitutionality of a case or of a law, it would be the Supreme Court the one in charge of controlling the convention, the Inter-American Convention on Human Rights. If a country has a system where every judge or a number of judges at the first level are in charge of controlling constitutionality, then those judges at the same time are in charge of controlling conventionality, as it is called. So we talk about the conventionality of a law or the conventionality of a case in front of a court, which means that you also have to have into account the chart, the Inter-American Convention, and not only domestic laws. If, for any reason, the courts at a first level are not authorized by their constitution to do conventional control, however, the court has developed a doctrine by which you at least should procure an interpretation which is, I would say, close enough or obedient of the Inter-American Convention on Human Rights. It's what we call interpretación conforme, conform interpretation, abiding interpretation. So judges would always need to know the convention, know about the cases that the Inter-American Court, leading cases that guide the interpretation, and be able at least to interpret in conformity to the convention in every case they are presiding, every case they have to rule. And that's very interesting because that always is calling the justice system to uphold the convention. That is something that, sadly, the US and Canada do not abide to. So many times there's a judging of human rights within Latin American countries, but then when it comes the time to consider if human rights are being respected in the Northern Hemisphere in the Americas, this is not controlled by the Inter-American Court. And this is interesting because, for instance, I learned that in Canada, there is self-representation in criminal cases, which is something absolutely inconceivable in Latin America and absolutely inconceivable under the Inter-American Convention. Why? Because if you want to have a due process of law, in our understanding, you must have technical defense. People are not prepared to defend themselves unless very low cases. But in the case of Canada, there are situations in which people might be even sentenced to jail, and they self-represent themselves. There's a very good accompanying and a process and so forth, but there's not professional technical defense. So that's interesting. And yes, I think we should move forward in trying to bring the US and Canada to the court and to the Inter-American human rights system. Is this a system that is sufficiently developed? No, I'm very critical of it. The number of cases that the court rules on per year are very little. So it's difficult to really build a tendency, an interpretation solid enough as we would like. European court sees and rules on a much larger number of cases per year, which is something that should happen in the Inter-American Court. And I would say probably there should be a different process and control of the selection of cases that go into the Inter-American Commission, and then that might be ruled within the Inter-American Court. So that is something that needs to be, I would say, revised, and I would be glad to be part of that process. So CEJA relates to the court and to the inter-American system in the sense that whenever we're training judges, prosecution, etc., we're always reminding them that it's not only domestic law, it's not only your constitution, it's the Inter-American Convention and also the International Convention on Human Rights, which are applicable in our constitutions because most Latin American countries also abide to the Universal Chart of Human Rights.